to give you a little bit of background, I'm a corporate lawyer in the team at Kingsley Napley. A lot of my work is investment work, so either acting on behalf of a company that is receiving investment, or on behalf of angels who are making investment, or even on behalf of smaller VCs. So that's probably about 60% of my work, with the rest being what you would call more traditional corporate work, like mergers and acquisitions and shareholder disputes and things like that. And I'll just let Emer introduce herself.
Yeah, so I have a very similar sort of practice with a mix of kind of more traditional corporate work, M&A, shareholders agreements, and then also acting on investments, again, both on the acting for companies when they're raising investment, but also investors when they're making investment, and whether that's angel investors or kind of smaller VCs or family offices. And typically, I guess given the sector, a lot of those businesses do tend to be kind of tech businesses or tech-enabled businesses as well.
Fabulous. So that's a bit about us. Now, setting the scene before we jump into the detail. So imagine that you have attended one of these Angel Academy sessions. You've seen the founders present. You really like the idea. You're sort of excited by the opportunity. So you followed up after the pitch session. You've had a couple of calls with them, you've done some initial DD, and you've decided you're interested in investing in principal. At this point, you obviously will be running your due diligence at the same time in parallel, because there'll be further due diligence to do. But we're going to have a think about what you should think about from a legal perspective. So you'd expect to see some legal documentation, I would say, round about now. Don't leave it until the very last minute, but I would say that. And also, obviously, have a think about valuation and any discussions you're going to have around valuation with the founder, because that's what's ultimately going to determine what percentage equity you're going to be getting, as well as the amount of investment that you're going to make. And yes, and think about timeline as well. So just making sure the timeline is understood, especially if it's near the end of a tax year, because that's always a bit of fun for a final EIS tax relief. So that's setting the scene.
So as Roberta said, we've only got a short amount of time today, so we're going to focus on some of the key investor protections that you would look out for in your equity documents when you're making an angel investment. But it's important to remember that no two investments are the same. So as well as kind of the businesses being different, which might impact on your approach to due diligence, the structure of the investment might be different, you know, how much you're investing, who else is investing alongside you, and that could impact on how much input you have on the documents. But the key really is that the more you do this, the more familiar you become with the process, and the more familiar the documents will become. And so then it's going to be easier as you go along to sort of spot anomalies. And if there's anything that you don't understand, obviously you can always draw on the group. That's the benefit of being part of something like Angel Academy. You can always ask someone or ask us as well. And one of your key protections is actually going to be to read the documents, so know what you are signing up to. There's obviously no perfect deal, and as I said, kind of depending on the scenario, if you're coming in as part of a wider round, or you're coming in on a later round where documents are already in place, you might be signing up to kind of the existing documents, so you might not be in a position necessarily to negotiate the terms, but it's more about understanding what you're signing up to, so you know you can make a decision as to whether you're comfortable investing on those terms. And as I say, practice makes perfect. So the more you do it, the more familiar you become, and the easier it will become. So.
Absolutely. And before we just go into the kind of investor protections that we'd expect to be included in some of the legal docs. Just a final thing to say about due diligence. View due diligence as a bit of an insurance policy. It's your chance to, look under the hood of the company, deal with the team, and things like that, so that you really get a feel for the business. So it is part of your insurance policy, if you like, as well as the warranties, which we'll touch on in a moment. And do due diligence, even if you're not the lead investor, even if you're co-investing. That's no. I'm sure you all know this, but there's no excuse for not doing due diligence. Right, turning to investor protections or things to look out for. So the first thing I would look at, if I got a term sheet from a founder, or if documents were already in existence, so there was a shareholders agreement or investment agreement and a set of articles already in place, and you were effectively signing a deed of adherence to those documents that are already in place, is I would have a look and see, are there different classes of share? If there are different classes of share, why are there different classes of share? Do they have different rights attached to them? Are the shareholders separated into sort of founders, investors, existing shareholders, and what rights are attached to each? So do they all have voting rights? Do they all have dividend rights? Do they all have capital rights? So think of it from a kind of voting and economic perspective when you're looking at that. Obviously, the kind of classic, especially if you have an institutional investor in there, is a preference share or some sort of preferred share. That normally just means that it ranks ahead of other shares, but they're all different. So just read the articles and make sure you understand how the shares differ, and obviously be aware that having different classes of share can impact on EIS. So if you're claiming SEIS or EIS, make sure that the class of share that you're getting works from that perspective. So something else to be aware of. So first thing to look at, how many classes of share are there? Why are they different? What are the rights attached?
And so a next key matter is going to be the consent matters. So the day-to-day business of the company is obviously the responsibility of the directors, and under the Companies Act, under company law, shareholders have sort of limited matters on which they would need to vote or have a say. So typically, as an investor, you're going to want to see a list of consent matters in the document. So these are things which the company cannot do without the investor's consent. And there has to be the right balance struck with this list of matters between, not wanting to inhibit the day-to-day running of the company and it being too kind of prescriptive, but also it being the key matters that could go to the value of your shares. So, for example, it might be things, that the company taking on debt over a certain level, or the company selling off certain assets, or the company amending the articles, which could then impact on your rights as a shareholder. And with these consent matters, firstly, it's not just whether there are consent matters, but that's a key thing. Find that list of consent matters, but then also who needs to approve those matters. So is it just a percentage of the shareholders that need to agree, or is it a percentage of the investors as a group who need to agree? So as an investor, you're obviously going to have more protection if those consent matters are investor consent matters rather than just shareholder consent matters, because obviously if it is just a shareholder consent matter and the founder still has a large percentage of the shareholding, then the founder could potentially be able to approve those matters without your consent, and then those consent matters sort of lose the value and that protection for you. So have a look for those consent matters, who has to approve them, and then check if there's any kind of deemed consent mechanism. So if something in the documents that says if you don't respond within a certain amount of time, you're going to be deemed to approve those matters. And so that's just, again, something to be aware of. So if any of these points come up in the future where you're asked to approve, then you're aware of those timelines within which you should respond. And then also looking at kind of control at board and shareholder level. So you're going to want to see who's on the board. Is that just the founders? or is the investors as a group, or perhaps one of the sort of larger investors entitled to appoint a director to the board? So really just, is there any other independent people on the board? And that might not necessarily be someone from Angel Academy, but sometimes it is just good to know that there is some sort of independent director on the board who's kind of being involved in those board meetings, etc., and can potentially feed back to the investors as a group. And then you're also going to want to look at who's in control at shareholder level. So, there are certain decisions under the Companies Act which require kind of the holders of the majority of the shares to vote, or the holders of, say, 75% of the shareholders to agree. And if a founder has more than 75% of the shareholding, then that's when those consent matters that we've just talked about are going to become really key, because as a minority shareholder, you might not have much influence on those matters, so your consent matters are going to be your protection.
Yeah, absolutely. It's interesting. I was looking at looking at a shareholders agreement today, and that it had exactly that. It had a shareholder, a founder who had a large percentage of shareholding, and the consent was set at 50% of the holders of 50% of the shares, which was him alone. So it looked on the face of it like there were investor protections, but actually in practice there weren't. The other thing to have a look out for is just information rights. So by that, we just mean how often is the company going to be providing you with information? What information is it going to be providing? Does it need to provide you with a report on a quarterly basis? What's going to be in that report? Does it need to provide you with management accounts? Will it go as far as sharing its board minutes with you, etc.? And I think just you having a think about what you require in order to monitor your investment. These are going to be early stage companies, so you kind of have to have that in mind, that they might not have loads to report against in the first instance, but what is it that you would like to see to just ensure that you're able to monitor your investment, and how often? And it's useful to have this stuff in the agreement, because it's something that you can point to, in your legal documents. It's something that you can point to in the event that you're not getting that kind of information. It's there ingrained in a legal document, rather than you just relying on, having a good relationship with a founder or whatever, although that is obviously also important.
So next, talking about rights of first refusal. So this is firstly, do the shareholders have a preemption right on issue? So that means before kind of shares are issued to third parties, are they offered to the existing shareholders first in proportion to your current shareholding? And this is just really an anti-dilution protection for the existing shareholders. So you can essentially, if you want to put more money in and maintain your shareholding, you have an opportunity to participate in future rounds. One thing to be aware of is that sometimes the articles say that this preemption procedure can be disapplied, for example, by way of a special resolution, so by way of the holders of 75% of the shareholders agreeing. So it's just really to be aware of that as well. And then there's also preemption rights on transfer. So that would mean before a shareholder can transfer their shares to a third party, that they're offered to the existing shareholders first. And with that, what you're going to want to make sure is included is what's known as permitted transfers. So this means a list of people that you can transfer your shares to without having to follow that preemption procedure. So that's typically going to be sort of to family members or to family trusts. And yes, so that's preemption rights on transfer is just really that's a sort of opportunity for you if some shares come up for or sale, that you get sort of the first bite of that before them going to third parties. But obviously it impacts on you as well, so making sure that those permitted transfer rights are included. Because I actually saw a shareholders agreement this week that had preemption rights on transfer but no permitted transfers rights, which can obviously be quite restrictive if, for example, for tax planning purposes you were wanting to kind of transfer shares to a trust or to family members. So that's also going to be a key one for you to look out for.
And this goes nicely to the question that we've just had from Tracy, who's asked, you know, how do you mitigate against, or how do you protect the value of your shares, and as an investor, you know, in the context of further funding rounds? Well, your preemption rights is a large part of that. If you're offered the opportunity to follow your money, to follow on, you know, in future rounds, that's one, you know, in a pro rata to your investment. Yes, that requires you to make a further investment, but you want to be given that chance, and not to be, you know, automatically diluted. Obviously, dilution, just in the context of things, is not a bad thing. It should mean, hopefully, that the company's doing very well, and it's able to raise more money, and therefore you have a smaller bit of a larger, you know, of something a lot more valuable. But preemption rights is the thing to look out for, Tracy, in terms of just making sure you're having that right. Okay, obligatory transfer events, very exciting. So other thing to look out for in normally in your articles is just to make sure that there aren't any situations in which you as an investor would be deemed to offer up your shares for sale. So these are called obligatory transfer events or compulsory transfer events, and should be hopefully pretty obvious in the documents. So the first thing to think about if you see them is, do they catch you as an investor, or do they just catch the founders, for example? And if they do catch you, in which situations could you be forced or to sell your shares effectively? This is sometimes in situations such as a breach of the shareholders agreement, or being very kind of depressing, your death, or other situations like that. Now, always keep an eye out to see if those are in there, and be really, really careful about ones that are very non-objective. So things like, if the board decide that you have caused the company a reputational issue, that is not something you want to be seeing catching you as an investor. So that's the first thing. The second thing when you're looking at these compulsory transfer situations is just ensuring that they do catch the founders. So should the founders cease to be employees, so they'd have to be, because they were, you know, needed to be sacked for gross misconduct, for example, that's worst case scenario, or because they decided to move on, or they resigned, or they became ill, or a family member of theirs became ill and they had to, you know, take a step back. In those situations, the ideal from an investor perspective is that those founders will be offering up their shares for sale, or at least offering up a percentage of their shares for sale. The reason that's important is because founders normally have quite a large percentage shareholding, and if a founder is departing, you're going to have to replace them. And to incentivize someone good to come and replace them, you probably want to offer that person some shares, and therefore, where do you get them from? If you issued new shares, you'd be diluting everyone. So ideally, what would happen is a founder who is departing, you know, offers up some of their shares for sale automatically. The company buys them if they can afford it, and those are then offered to, or given to, the incoming replacement founder, if you like. So that's something to be really aware of. And when we say leaver provisions, that's what we mean. So effectively, leaver provisions are compulsory transfer provisions, but normally they have attached to them sort of good leaver and bad leaver, and sometimes neutral leaver scenarios, whereby the shares that the founder offers up, they offer up a different number, or they offer them up at a different price, depending if they're determined to be a good bad or neutral or very bad. You see all sorts of things. Leaver. So something else to think about. So when you're looking at your documents, have a think about what would happen if a founder left for whatever reason.
Which ties neatly on now to the restrictive covenants. So it is obviously, you'll have all, I'm sure, come across kind of restrictive covenants in employment contracts, etc. But it's also common to have restrictive covenants in the shareholders agreement. And these will be, you know, restrictions on competing with the business, soliciting clients, or soliciting employees for a certain period after a person ceases to be a shareholder. And this is, but with this, what you want to look out for is that you as an investor aren't caught by these provisions. Obviously, you're going to want to make sure that the founders or other employees who are also shareholders are caught by these provisions, because you don't want to sort of invest in a company and then a few months later the founder's sort of deciding, oh, actually I'm gonna kind of leave this business and start up the exact same business somewhere else. So you're going to want to make sure that the restrictive covenants are included to protect your investment, but you don't want to because you want to prevent the founders from kind of walking away from the business, but you don't want to be caught by those provisions, because you may have, say, an investment in a similar business, for example, which you know, if you've just got a small minority shareholding in either business, you don't want to be caught by that. So and potentially, you know, then that being a breach of the shareholder agreement, which then is caught by the obligatory transfer events. So key thing is making sure you've got the restrictive covenants in there that catch the founders, but you're not caught by those provisions.
Yeah, I think that's especially the case if you're thinking about doing some consultancy work for the business, for the startup, or being a director or something. That's where you might be caught by these definitions. So just something to look out for. That's all.
And so the next one is drag and tag rights. So a drag right is where the majority of the shareholders want to sell their shareholding in the company, and they want to be able to drag the minority shareholders into that sale. And this is a common protection, which even as a minority shareholder, you're going to want to make sure is in the business, because actually you don't want a minority being able to essentially block the sale of a company if a sort of great opportunity comes along. But what you want to be aware of with a drag right is what the percentage is set at. So what is classed as that majority that can drag the minorities into the sale, because again, you're going to want that to be a sort of high enough percentage that it's not just, say, the founder potentially, but also, you know, that there's kind of buy-in as well from potentially the investors to ensure that drag gets affected. And then on the flip side of that, there's also what's known as a tag right, which is a minority shareholder protection. And this is where if the majority have found a buyer and they're selling their shares, but they don't exercise that drag right, then the minorities can tag along and force them to ensure that the buyer extends the same offer to them, to the rest of the shareholders. So make sure that both of those provisions are included, because sometimes you do see, say, a drag right included, but not necessarily the tag, which is obviously a protection for the minority shareholders as well.
Yeah, absolutely. One final thing, warranties, but do put your questions in the chat. We are having a look at it, so we will have time, and I can cut the warranties short for exciting questions, so do ask them. Final thing is just warranties. So what we would expect in an investment agreement or a shareholders agreement where you're putting in money and being issued with new shares is a selection of warranties. Now, a warranty is a statement of fact about the company at the date that you make your investment. So it might be something like there is no litigation, you know, the company hasn't received an enforcement notice, the company's always paid its tax, the company has X number of employees. And the thing about warranties, they can be overwhelming because there can be lots of them in some situations. But the thing to think about is, where is the value in this company? and have I got a warranty that protects that? So in the respect of a tech business, really what you'll be looking at is, does the company own all the IP? Who developed it? Does the company own it? So you want a warranty that says the company does own all of the IP in the company, and you probably want a warranty about the shares. You know, that there are X number of shares in existence in the company, so that you're clear as to share capital. So that's the way to kind of think about them. So that's what a warranty is. Warranties can be given by the founders or by the company or by both. Ideally, as an investor, they'd be given by both. So the founder has their neck a little bit on the line, which sharpens the mind, and ensures that if there is anything that they haven't disclosed, they disclose it at this stage. So that's a warranty. So another thing to kind of look out for is a protection. And we'll just turn to some questions. So, quick question: what are the legal docs you'd expect to see as an investor? Well, you'd expect to see, if your founder's very organized, a lovely term sheet setting out a summary of the key commercial and legal protection, commercial and legal terms. If they've already been through a raise or a couple of raises, you'd expect to see an investment agreement / shareholders agreement / subscription and shareholders agreement. All effectively mean the same thing. Don't be distracted by that. And a set of articles. And you would just be signing a little deed of adherence or a subscription letter, adhering to those documents that are already in place. If those documents aren't already in place, because this is, say, the first equity round or the first equity round of substance, at that stage you might see a shareholders agreement or investment agreement and a set of articles for the first time. And so you'd be signing up to actually those documents. So that's the sort of thing you'd expect to see.
Okay, so just summing up then, so firstly, I suppose, do your due diligence, as we talked about. That's going to be key. Making sure that you read the investment agreements, investment documents, and identifying any anomalies. And if there, if there might be, there might be a reason for certain terms in the document. So if it looks unfamiliar, ask why it's there. Ask another investor in the group. Take some legal advice. Look at the structure of this deal. Who else is investing in the round? Have there been previous rounds? And just remember that, of course, there's never going to be one ideal scenario. The documents are all different, the deals are all different, but these terms are there to protect the founders and to protect the investors. Ideally, what will happen is you'll sign up to these documents, put them in a drawer, and hopefully never have to look at them again, because it will all be smooth sailing. But really, they're just there in case something does go wrong. So whether that's you're not getting the information that you want, then you can kind of pull it out and point to it and say, no, you should be providing me with this information. And then, as we said at the beginning, making sure that you understand what you've signed up to, and that the documents include some of those key protections that you'll usually expect. And as you said at the beginning, making sure that you'll learn from experience. So the more you do this, the more familiar it will become, and hopefully the easier it will become. But in the meantime, ask if you don't know.